welcome back to Communication and Law. We're going to dive into the judicial system a bit more in this video. Before we do, keep in mind that the judicial system in the United States is really a collection of 52 different judicial systems. That is, we have one at the federal level, but also each of the 50 states and Washington, D.C. have their own court systems. Now, as we get into this, it'll also be important to understand the role that facts play and the role that the law plays. Facts are what happened in a case, and then the law is what should be done because of those facts. Why is that important? Well, because the facts are really only considered in trial courts. This is what we call courts of first instance, where you have either a judge or a jury who's looking at the facts of the case and making a decision about how the law should apply. Appellate courts are the opportunity for people to challenge the decision of the lower trial courts or lower appellate courts. Appellate courts are not designed to look at the facts of the case. Rather, they're only looking at how the law was applied, right? So they're not going back and reevaluating whether or not someone, should be guilty or not guilty of a crime. They're looking at whether or not the law was applied appropriately, whether due process was adhered to, whether there was proper chain of custody for evidence, that sort of thing. It's not looking at the merits of the case on the facts themselves. Okay, so as I said, we're going to look at the federal system in this video. And of course, we have the U.S. Supreme Court as the highest court of the land in the federal system. But the federal judicial system also comprises the U.S. Court of Military Appeals, the U.S. Court of Appeals and its 91 U.S. district courts, as well as the U.S. Court of Appeals for the Federal Circuit, which is a little bit of an oddball that examines things like international trade or veterans' appeals and that sort of thing. Now, other ways in which trial courts and appellate courts are different. Trial courts, a jury may be used, and you normally have a judge that sits in. This is where cases begin. Appellate courts, juries are never used, and instead appeals, challenges to the lower rulings. Those appeals are heard by a panel of judges, and this is how cases proceed. The federal court system can look at a variety of cases that might involve the U.S. Constitution, U.S. law, U.S. treaties, how ambassadors from other countries are treated, may look at questions of maritime law, so shipping and commerce across international borders. It may look at cases where the United States is a party to a lawsuit. It may look at cases where two or more states have some legal conflict. May also look at controversies between a state and a citizen of another state, or between citizens of different states. The U.S. Supreme Court is the oldest federal court. It's been around since 1789, and it can exercise original jurisdiction. That would be trial court jurisdiction. However, most of its function comes in the form of its appellate process. So most cases reach the Supreme Court through the appeals process. In order to get to the Supreme Court, or I should say in order for the Supreme Court to hear a case, the plaintiff, the person bringing, or the appellate, should bring a request to the court, and this requires a rule of 4 in order for the Supreme Court to hear it. That is, 4 of the 9 justices must think that the petition has merit, and if so, they will grant what's called a writ of certiorari. It's a Latin term, and it's pronounced differently by different people. But it basically means, yes, we think there is a case here that merits review by the Supreme Court, the highest court in the land. It may be a constitutional question. It may be a question about the way process was handled. But only 60 to 80 cases are granted this writ of certiorari every year. Once the Supreme Court does agree to hear a case, they'll schedule the initial oral arguments, which are about 30 to 60 minutes on each side. And the parties of the case and their legal attorneys or representatives must also submit legal briefs, which are written legal arguments, to the court so that they can study these before the oral hearing. Additionally, the appellant, the person bringing the case to the court, must also provide all records from the lower court proceedings, a transcript from the initial trial, all rulings from the lower courts, and any other relevant material. After the 9 justices study the briefs, they hear the oral argument. They also review what's called amici curiae. These are briefs submitted by friends of the court. In Latin, that means friends of the court. And this might be from various special interest groups, the American Civil Liberties Union, the National Rifle Association, whatever it might be. And they would submit an argument or a letter, a brief of support, a document of support for one side or another, or they would weigh in on the case, giving their insight on the matter. Once the case has been heard, the Supreme Court would then issue a decision and its opinion. The court's opinion is the majority opinion. So when you have 5 out of the 9 justices who agree, they will issue the ruling in the majority opinion that provides the rationale for the decision. That majority opinion is usually written by one of those 5 or more Supreme Court justices. Sometimes you will also have a concurring opinion. This is when one or more justices agree with the opinion or the overall outcome, but they agree for reasons different than those expressed in the majority opinion. And so then those justices would write an additional document announcing his, her, or their concurring opinion. In addition, many times the court will issue a dissenting opinion. This is where those justices who disagreed with the majority, so this would be up to 4 of the 9 Supreme Court justices, if they disagree, they will often write a dissenting opinion that expresses why they disagree with the outcome of the case. This is important because it can hold weight when it comes to arguing future legal cases, even if the majority opinion and even if the precedent that was established through the Supreme Court's decision and outcome, even if that ultimately is the law and the legal ruling, as future cases get challenged, it's important to have these dissenting opinions on the record so that we understand the reasoning and the debate that was held within the Supreme Court and among those justices about these cases. Now, in rare circumstances, we'll have what's called a plurality opinion. And this is when you simply cannot get a majority. You cannot get 5 justices to agree on anything, on a particular majority opinion and the outcome of the case. And so in that event, you would have what we call a plurality opinion. And basically that is however many people agree, that's the most popular opinion. Right? So you might have 4 justices agree and then 5 others who just can't agree on anything, right? And so in that case, those 4 justices would not present a majority decision because they don't have a majority, and instead we call that a plurality opinion. All right. In addition, there are a couple of other sort of unusual options that the Supreme Court has. And it can issue what's called a per curiam opinion. And this is where you have a majority opinion or a court opinion, but it's not written by a singular justice. Instead, there's no one person that's sort of tasked and given the recognition or honor of writing that majority opinion. They just call this a per curiam opinion. Or on sort of the flip side, you can also have what's called a memorandum order. And this is where the court would give the vote. So they might say, okay, the decision is 5-4 in favor of the appellant, right, or whoever it is. But they do not give any other information, right? They don't give a written rationale or opinion for the case. Beneath the Supreme Court, the lion's share, the bulk of the work that's done in the federal judicial system is through the district courts. These are the trial courts of the federal court system, and each state has at least one federal district court. We also have the U.S. Court of Appeals. There are 13 circuits in the U.S. Court of Appeals, and there are 179 authorized judgeships in the Court of Appeals as of 2021. There's also what's called sitting en banc, which is just when a larger panel of judges, usually 11, will hear an appeal. This is sort of an unusual circumstance as well. If you want to know what federal judicial circuit you're in, here's a map you can see. Here in Florida, we're in the 11th district. So any federal cases first fall under that circuit court, the 11th Circuit here in Florida. Federal judges are appointed for life under Article 3 of the Constitution by the President and with the advice and consent of the Senate. So all federal judges have to be confirmed by the Senate, and they can only be removed by impeachment. Likewise, former justices can serve as judges on lower federal courts after retirement if they will. So they can come off the Supreme Court and serve on lower courts if they want to. So that takes care of what we need to talk about for the judicial system at the federal level. We'll dig into courts at the state level in another video.